for some solidarity with the brain. Yeah. He would buy you.
Today, so I'm just gonna like spaz out right now.
Drink like 2 energy drinks while you're judging.
Yeah.
Alright, y'all ready? Plan the United States federal government should make individuals who file claims against their employers and do not have regulars and immigration status eligible for TV's contention. 1. The exploitation of undocumented workers and violence that is so omnipresent has been rendered, but all failure ensures the application of basic workplace protections is a failure of our personal political commitments. Gross 1980 saw a group carrying picket signs learned, keep it living next to a crib window with a sweatshop and passing all the time, didn't even notice. The rest of us are morally neutral, strike even in our neighborhoods and our business when others' rights are being violated. Moral neutrality. Neutrality is passive injustice. That is one of the most pernicious consequences that those suffering injustice will do nothing because they are afraid to stand up with those support. Just requires all of us to use our power to prevent wrong to be done to others. Some have been permitted to benefit through the unjust exploitation of others by denying them the right to participate in the workplace decisions affecting their lives and subordinating the right to safe and healthful workplace considerations of profit data and principles used to justify breaking the promises to reduce all human behavior to market behavior. The moral choice, the constant, the basic foundation of law must be made in ways that protect and empower those most in need of protection. Lack of regular immigration status causes widespread exploitation of undocumented workers. Civil action provision of the TVPA was expanded, but still perpetuates the distinction between labor exploitation and trafficking that makes effective liberal mobilization impossible. This is Kim and 9. Pervasive labor violations of these works has been revealed. An underage worker reported feeling like a slave, although U.S. law prevents labor abuse and provides civil remedies. Many of the workplace violations will remain unvitigated as a result of workers' immigration, detention, and deportation. These examples highlight the inherent tension between the restrictive goals of immigration laws and expansive civil rights laws. Undocumented immigrant workers who experience workplace exploitation are uniquely impacted by the divergent goals in theory. Undocumented workers victimized by exploitative unemployment practices may act as private attorneys general. Enforcement of workplace harms may sue their employers in practice. The goals of immigration enforcement take precedence over the individual rights of undocumented workers when these workers are deported. Workplace violations are not prosecuted, but the workers of the nation suffer. The TVPA is a strong prosecutorial purpose and is designed to criminalize traffickers, yet it also protects a previously unrecognized class of undocumented workers by providing legal immigration status. TVPA was amended to include a private right of action, thereby codifying a new class of private attorneys general representing an effort to extend civil protections to trafficked persons. The law's distinction between immigrant labor exploitation and human trafficking. The latter receives the law's protections as victims in involuntary servitude, while the former is not as undocumented workers are perceived to be an inclusive relationship with their employers. The conceptual distinction between trafficked workers and immigration victims of exploitative labor exploitation, if any, is ambiguous. The law continues to be implemented in a manner that distinguishes between trafficked workers and other immigrant victims of labor exploitation. The perceived threat of deportation is the largest internal link to employer manipulation and widespread exploitation. Kim and 9, the constant threat of deportation alienates workers with precarious immigration status from access to justice for workplace violations. Undocumented workers can complain about working conditions about with retaliation by employers. Employer retaliation may provide a legitimate basis for removal. This reducing employer accountability by reducing intentional incentives for unscrupulous employers to employ and undocumented workforce. Undocumented workers typically experience a greater number of unlawful working conditions. Former supervisors at a plant stated that the plant preferred undocumented workers because they were less likely to question working conditions. The poultry processing industry's death and injury rates are far higher than those for manufacturing as a whole. Human Rights Watch determined federal law and policy on immigrant workers are massive contradictions. The worst they contain incentives for employers to violate their rights, failure to attack this exploitation by giving individuals full participation in legal, political, and workplace struggles. Allows the creation of a disposable population to only give individuals the agency to control their own political existence, can ensure viable life. Gross 98. These rights protect the special moral status of persons, secure for them at least a minimum respect required for citizenship in a decent and just society. History provides proof that the human life is cheap, readily sacrificed in support of some economic, political, military, or even religious interest in a just society. There can be no throwaway people. Although one is no less dead, the society certainly treats the causes differently. Even if physical security and subsistence rights were respected, more is required for a life to be truly human. That health and safety, a full human life begins, but not having to depend on others. Benevolence begins with people understand that they inherently deserve just treatment. Full human life requires participation in the political, economic, and social life of the human community. To enjoy something only things discretion of someone else will is precisely not to enjoy a right to the primary purpose of a national labor policy should be defined a moral basis for achieving human dignity, solidarity, and justice. The very purpose of the U.S. was to enable the powerless to restrain the powerful. Democracy's working only when it meets this test. Disposability of populations, collapse of the public sphere makes global war and structural violence inevitable. Must reframe labor relations against market fundamentals. And Jerome and 6 anti-democratic elements can be found in many of the political processes that characterize U.S. sovereignty and power at the top of the political hierarchies, matched by an aggressive attack on dissent throughout the body politic, and by entire populations now seen as disposable. State sovereignty is no longer organized around the struggle for life, but an insatiable quest for the accumulation of capital, leading to necropolitics, market fundamentals, and trivializes democratic values and enshrines rabid individuals in the current sum total being the war of all against all to replace any vestige of shared responsibility. Responsible citizens are replaced by entrepreneurial subjects forced to face increasingly difficult challenges. The social world, one hidden hand in the market will never work without the hidden fist. Public resources are diverted from addressing the fate of the world's poor. The refusal to ensure equitable working conditions for undocumented workers premised on their visibility, because we see them in our everyday lives. Enforcement alone fails. We have to provide incentives for people to exercise private rights of action. Benson and 2, why do we have this particular disposition not to see people living and working among us? It's part because there are social fabric conditions. It's not to see workers. We may be insulated from recognizing those who do a variety of work in our society. There's a basic tension to most of us that although we do treasure our sense of being Americans who treat all equally, when we are face to face with human, we struggle with seeks also to determine if this person is a good or legal. I'm asking us to examine why we don't try harder to shape immigration laws. I'm not naive enough to believe that the federal or state prosecutions can really solve the economic and social conditions of lead employers to rely upon undocumented workers and increase these efforts of a side effect of helping us gather information about the real lives of these workers. We need to dismantle the obstacles for the undocumented to recover adequate remedies under the law. We need to recognize that the government enforcement of the law will never be sufficient to encourage private rights of action behind every legal label is a person this invisible balance against disposable populations, largest proximate cause of war and genocide, shepherd, using bourgeois and four absolutely essential to blurring the distinction between wartime, peacetime violence, close attention to the will, violences, producing destruction of everyday life, sometimes pathologies. Class, race, and gender inequality, violence continuum also refers to these schemes capable of reducing the socially vulnerable and expendable non-persons, and assuming the license to kill, maim, or soul murder, there is an even greater risk of failing to sensitize ourselves to the sentiments daily enacted these are the invisible genocides, not because they are hidden from our view, but quite the opposite. The things that are hardest to perceive are those which are right before our eyes. We need to exercise a defensive hypervigilance to the less traumatic committed, even rewarded every day. Acts of violence, the random participation in genocidal acts and policies possible, constant self-mobilization for alarm is a reasonable response to late modern history's chronic state of emergency. There's no primary impulse out of which mass violence and genocide are born. Is ingrained in the common sense of everyday social life. The mad, the differently able have often fallen into this category of unworthy living collective denial, must represent a recognition of prerequisites for mass violence and genocide. The harbor, the priming that push social consensus towards devaluing certain forms of human life, potential to as trafficking, labor exploitation must be brought within the trafficking framework. The current model maintains a colonialist relation to both victims and the trafficking enforcement regime as a whole. The plan is the best method to short-circuit the victim-whore dichotomy. This is DeSalle. 7. The privilege and power that the U.S. has over other countries acts to reinforce the power hierarchy and control that maintains the inequalities of neocolonial relationships between nations. This crucial Western policymakers and others in position to privilege the Senate of Western partisan women's agency and constructing non-Western women is needed to be rescued. Perpetuates the idea of the weak, other, and the powerful Western. The re-inscription of Western imperialism and colonialism, evidence of the creation and implementation of trafficking policy, more inclusive and constructive discourse when it takes into account a variety of conditions, the agency of men and transgender individuals, as well as the perspectives of sex workers who do not have rights to sex workers due to the illegal nature of the work when the subject is not a minority of women who are due. We should be able to give credit where it is due to women and transsexuals, as well as men who dare to make decisions about their lives by leaving their homes to work abroad, no matter what kind of work they have, to do by accepting the current abolitionist framework. Multiple realities are ignored. A more inclusive perspective takes into account other types of work is crucial. It's important to move away from moral lens and to move toward protecting migrant workers from unsafe labor conditions by putting all forms of labor by defining sex work as an economic activity that's often used in combination with other types of work. Migrants and sex workers will not be stigmatized and marginalized due to the association to being labeled as the prostitute migratory loans, but also address immigration laws that are less punitive, more equitable migrants. Western trafficking discourse, the anti-trafficking discourse of binaries and stereotypes of the third world, racist distancing is necessary conditions for genocide war. Chang in 1997 examined the American century. The racialized space that the U.S. provides an opportunity to explore the racial structures that undergird the nation's state. My question: the effects of state apparatus, the census, and its role in reproducing racialized subjects. My question: legal doctrines and their role in reproducing racialized identities. The point of critiques to examine the political economy of race for immigration includes a strong racial convention as racism is dominant thing is not biological heredity, but expandability of cultural difference. Nativistic racism signifies that nativism and racism are mutually constitutive and operate intended to preserve a specific conception of the nation. Insufficient attention has been paid to the diversity and competence with the widest examination of the immigrant may help us to develop an emancipatory politics that will move us toward a radical and pro democracy, expanding the chain of equivalence between the different struggles against oppression. The task of the left, therefore, cannot be to renounce the democratic ideology, but on the contrary, to deepen and expand it in the direction of radical and pro democracy. Solidarity may be invoked, establish a chain of equivalence between different groups in their struggles against oppression. White supremacy located within the confines of the nation state tells them part of the story. Once we escape a national imaginary, it becomes easy to deepen the chains of democratic equivalence, linking the struggles of those who have been in the U.S. for generations with those who arrived more recently. The plan allows petitioners to circumvent the TV's victimization and prosecution requirements. Civil action gives agency to plaintiffs and allows them to direct their own case will be protected from deportation. This is Kim and 9. The link between TV's eligibility and cooperation with law enforcement is too onerous, subjecting trafficking victims to further trauma. The inherent selectivity in the prosecutorial process, leaving the trafficked person excluded from protection benefits, ultimately full access to justice. And the major criticism is conflation of prosecution, trafficking, anti-trafficking policies, focus funding, and resources on enforcement of only sex trafficking crimes, thereby withholding protection and alienating trafficked persons in their labor sectors. Trafficked plaintiffs have sued the perpetrators in civil court, received TVPA-related immigration relief, allowing them to serve the civil rights unimpeded by immigration restrictions. The pursuit of civil relief directs attention away from the criminal process, allows trafficked plaintiffs to direct their own legal case, vindicate civil rights violations left unvindicated by law enforcement that will benefit the beginning of the undocumented work context. The laws enable trafficked workers, private attorney general were extended to all undocumented workers who suffer civil rights violations in the workplace. Potential 3 solvency current expansion TVPA takes out your DAs but doesn't solve plan empowers individuals, changes employer behavior and leads to positive legal externalities. This is like Kim and 9. The TVPA may cover a broad spectrum of work abuses. However, distinction between trafficked workers and exploited undocumented workers continues to play out in the law. Immigration relief should be extended to undocumented workers because they play an important role in the furtherance of substantive legal norms and societal values. Undocumented workers injured by their employers can fill the gap by holding their employers directly accountable. Civil litigation may also be an important source of empowerment for injured workers. May utilize the civil process to hold their employer accountable. The prioritization of immigration enforcement, the absence of effective labor protections allows unscrupulous employers to take advantage of workers with impunity. The threat of lawsuit for workplace violations creates significant financial disincentives for an employer to engage in exploitative employment practices. Litigation on behalf of the undocumented workers have also encouraged labor reform. These cases demonstrate that some undocumented workers have also have access to the civil justice system and generated both private and public benefits. This case also illustrates the incredible challenges that undocumented workers face in suing their employers. Good. Okay, thanks.
Okay, so you make these individuals eligible for T visas. What are the requirements of T visas?
The only requirements for
them to get a T visa under the eligibility track that the plan establishes, with that they file a civil suit against their employer for labor violations.
But there are other eligibility criteria that exist.
No, there is a second eligibility track that has another set of criteria.
Well, no, the T visa, in order to get a T visa, you have to commit to cooperate with law enforcement.
Under the current eligibility track, the things you're
I guess that's what I'm curious. So you change the eligibility criteria for T visas.
We create a second eligibility track for the T
you
visa.
create a second eligibility track for the T visas, but saying T visa, still T visa, right?
Yep.
Okay. So your Kim evidence says, benefits may be gained if the undocumented worker context of laws enabling the traffic worker as private attorney general were extended to all undocumented workers who suffer civil rights violations in the workplace. You make these individuals eligible for visas. Which evidence do you read says that these undocumented workers have the resources to bring suits against their employers?
The last piece of Kim evidence
this piece of Kim evidence,
and the last piece of Kim evidence in the trafficking advantage both say that empirically, the civil remedy has worked for trafficking victims of sex trafficking. Unfortunately,
so how many people would be affected by the plan?
Well, over the last, enacted in 2008, the civil remedy led to, over the last year and a half, and since that article was written, led to 25 suits on the behalf of sex traffickers. We believe it would probably lead to a lot more than that because it was.
And you have to remember that the piece of Kim's relevancy evidence we have says that it leads to positive legal externalities, which means that when employers calculate the cost advantage for committing workplace violations, they have to include the possibility of a civil suit being conducted against them.
But that doesn't really get. That doesn't answer the original question, which is which type of professions and how many people are affected by this. Like you read evidence that says
by the plan or by workplace violations?
No, by the plan. Well, the ones that
people that are undocumented. Everybody that's undocumented is potentially affected.
11 million, approximately 11 million undocumented people in America. So all of them have the ability to bring suits against their employers now.
Yeah, absolutely. Yep.
Okay. They all are now quote eligible for T visas. Who determines whether or not they get a T visa?
The Kim evidence. I'm sorry. I was going to say the answer previously. The Kim evidence says to be probably around a couple hundred suits that.
Probably around a couple hundred suits that will come out immediately. Okay. So again, you make these individuals eligible for the T visas. Who has the final say on whether or not they get approved?
Who is the final
say? They are not admissible. You're not admissible if you have committed immigration law violations. Do you eliminate that admissibility requirement?
Under the T visa, it's the T visa as it stands now, undocumented immigrants can get them. Obviously, people who've been trafficked. The T visa itself allows you to sort of vet that inadmissibility, because obviously
Can I speak
the
on
limit
this
who exist.